Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip, continuing on with the changes to the 2020 Georgia Association of Realtors contracts. We are continuing on in the series, and today we are going to talk about changes they made to the seller's property disclosure. Now, please check out the other videos I have done going over the changes to the other contract forms. And those links are below, or check out the playlist 2020 GAR contracts. So, not a lot of changes to the seller's property disclosure, but some interesting ones. Now, part of these changes GAR has been working on all of 2019. So, if we look at the fixtures checklist, which is paragraph D. So, okay, let me back up. The form we're actually talking about is F301, Seller's Property Disclosure Statement Exhibit. And paragraph D is the fixtures checklist. And this paragraph has been reworked by the GAR Forms Committee, as I mentioned, all year. So there were changes they made in mid-2016 and then changes they made again in 2020. And the changes that they have made basically in this section of the exhibit have to do with what happens if a seller has agreed to leave certain fixtures or items with the property, but they get damaged or break down prior to closing. What is the seller's responsibility for that? What recourse does a buyer have for that? And then an additional section that they added, or additional language that they added for 2020, is what time frame, how long after closing does the seller have for items that they did not take out. So let me read what the version will be in January 1st, 2020. This is paragraph D, fixtures checklist. Directions on how to use. It is often unclear what constitutes a fixture which remains with the property versus personal property which does not remain with the property. To avoid disputes, sellers shall have the right to remove all items on the checklist below that are left blank. The items on the checklist below that are checked or marked shall remain with the property. All items remaining with the property shall include remotes and or accessories necessary for use. Unless otherwise indicated, if an item is left blank, the seller may remove all of that item from the property. For example, if refrigerator is left blank, seller may remove all refrigerators on the property. This checklist is intended to supersede the common law of fixtures with regard to the items below. The common law of fixtures shall apply to all items not on the checklist. Seller shall remove all items left blank below prior to closing or the transfer of possession, whichever is later. Seller, this is new verbiage for 2020. Seller shall lose the right to remove those items not timely removed, but shall remain liable for the cost of the buyer having to dispose of such items, provided that the buyer disposes of them within 30 days after closing. In removing items, seller shall use reasonable care to prevent and repair damage to the area where the item was removed. Items identified as remaining with the property shall mean those specific items as they existed in the property as of the offer date. No such item shall be removed from the property unless it is broken or destroyed. In the event such item is removed, it shall be replaced with a substantially identical item, if reasonably available. If not reasonably available, it shall be replaced with a substantially similar item of equal quality and value or better. The same or newer model of the item being replaced in the same color and size and with the same functions or better shall be considered substantially identical. This section entitled Fixtures Checklist shall survive closing. So a couple of things to think about there. Again, one is if something had been identified as remaining with the property and it gets damaged or broken, what happens? So that's addressed there, and all of this whole paragraph is, this whole section does survive closing. The language that they added for 2020 is if a seller had initially identified something as leaving, not staying with the property, but they do leave it with the property, what does that mean for a buyer? For example, the seller wanted to take their pool table with them when they moved. However, this is just an example. However, throughout the course of the move, when they priced how much it was going to cost for the movers to move that pool table, they decided to leave it in the house, and with the rationale that, oh, the new buyers will love the pool table. We enjoyed it, they'll enjoy it. Well, the new buyers may not have wanted that pool table, and now there is a cost associated with the buyer having to remove that pool table from the property. So now that is addressed, that the seller removes the right to remove that, not timely removed, but shall remain liable to the buyer for the cost of that, as long as the buyer does remove it within 30 days. So that's what that's about. So make sure your buyers and sellers really understand what that paragraph is about, and responsibilities and liabilities and costs associated with those items. Now, the only other changes they made to the seller's property disclosure exhibit is back under paragraph 5, where it talks about systems and components. They added a subparagraph 5G, and it says, are any systems or components subject to a lease or rental payment plan, i.e. HVAC, security system, appliances, solar systems, etc. And that's for the seller to mark yes, no, and then an explanation. So they've added that. And then back actually under the fixtures checklist, they've added 2 new items. One is an above ground pool, and the other is a car charging station. Indication of the times. So anyway, that's about it for the changes to the seller's property disclosure statement exhibit, and just wanted to bring those to your attention. Again, please watch all the videos regarding the 2020 GAR contract changes, and thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.